Welcome all. I am Dr. B.S. Patil and I am making a presentation on module 12, Access to Justice and Children. The content writer of this module is Mrunmay M. Vaidya and I am making a presentation on her behalf. We both are connected with V.M. Salgaonkar College of Law, Goa. In today's presentation, that is regarding access to justice and children, the scheme that I have prepared for the presentation would be a brief introduction about the children rights, plus the legislations which are protecting the rights of the children, procedural protection for the children's. In case a child is suffering or is a victim of any crime, in such case how the grievance redressal mechanism has been built in, and then finally I will be taking up a judicial view on these legislations. However, when I take up a discussion on access to justice and the children, the meaning of access to justice has to undergo a certain structural changes. Here, traditionally access to justice means access to the court. A person aggrieved should have an access to the court. That is what the access to justice means in a traditional sense. But when we take up the discussion on access to justice to the children, it takes a different view. So, therefore, here we are going to study access to justice in a modern view, wherein we are trying to look into the law which protect the rights of the children. How protection of rights of children becomes access to justice. The reason being, the children being a vulnerable group, children being a group which are subjected or which are potential to be subjected to exploitation, they need a certain kind of additional protection. Plus, the fragile mind of the child and immature minds of the child leads to certain kind of wrong decision which may tend to put them into difficult situation. So, therefore, there is a need to look into the meaning of access to justice in a new sense. So, therefore, access to justice here means special nurturing, special provisions to provide for all round growth, healthy environment for the child, as well as overall well being of the child. How these things are assured by our present legal system. So, that is what we are going to look into in today's discussion. Do the children are vulnerable? What kind of child can be subjected to vulnerability? Are there any specific kind of children who are particularly very safe compared to the other children? The answer for these multiple questions which frequently comes to the minds of the people is that all children are vulnerable for exploitation. Child labor, it is a kind of an exploitation which a specific kind of child could be exposed, that is economically weak, belonging to a family of economically weaker section. But whereas when it comes to sexual abuse, trafficking and other kinds of child abuse, any child could be subjected to such kind of treatment. And mostly the situation would become much more difficult when the child is subjected to legal proceedings due to such difficult situation. So, therefore, any kind of child could be subjected to vulnerable situation. Then the question arises, who is a child? So, when it comes to qualification to be a child, the age determining factor has been different for different purposes. So, based on the purpose, a different age has been fixed. So, if you take the example of marriage, under the Hindu law, the marriageable age or the adult age starts for boys from 18 years and for the girls it is 21 years. When it take up Guardian and Wards Act, the age of majority is decided based upon whether the person is under the custody of a natural guardian or under the guardian appointed by the court. So, the age would be accordingly would be 18 and 21. When it comes to right to education, the age differs, that is the 6 to 14 is considered as child. When it comes to mining, under the Mines Act, a child cannot be employed in minings or mining activity. So, only a child who is above or only the person who is above the age of 18 could be employed under mining activity. So, therefore, age here would be 18. When it comes to Child Labour Regulation and Prohibition Act, the age fixed is 14. So, any child below 14 years of age cannot be employed in any kind of hazardous industries. So, therefore, the age factor differs based upon the purpose. So, when we look into legislations, we are going to look into 4 important aspects of these legislations. Number 1, whether these legislations are providing for social justice, non-discrimination, and very importantly equality and empowerment. So, taking these into considerations, I am going to put up certain of provisions for discussion. First, I will take up Constitution and the child. So, part 3 and part 4 of the Constitution of India provides certain provisions where child rights have been protected. Under part 3, the article 15 speaks about no discrimination among the citizens, but whereas there is a protective discrimination where any law in favor of women and child could be made. So, that is article 15 where the legislatures or we can say the government has the power to make a law favoring the children. Article 21A provides free education, that is compulsory and free education between 6 to 14. Article 39A, which falls under part 4 of the Constitution of India, provides for provisions where health and the strength of the child should be protected and encouraged. And then 39A itself again provides for a situation where a child should not be allowed to take up a job which is unsuitable for its strength and the age. So, that is a provision where a clear cut mandate is given to the state that to make a provisions where such employment is avoided or prohibited. Finally, article 39F, which provides for opportunities and facilities to be provided to develop, grow in a healthy manner, conditions of freedom and dignity, and even a protection against exploitation. So, all of these provisions have been made, the mandate have been made by the Indian Constitution. So, moving from Constitution to the procedural protection for children. Traditionally, we have 3 legislations which deal with criminal laws in India, that is Indian Penal Code, Criminal Procedure Code and Indian Evidence Act. So, we are going to look into these legislations specifically from the point of view of child. So, let me take up first Indian Penal Code. Under this Indian Penal Code, there are 2 age is been fixed. One is below 7 years and another is between 7 to 12. So, when you take up a child below 7 years of age, there is a presumption in the law where it says that a child below 7 years is incapable of holding mens rea, that is guilty mind. Therefore, below 7 years of age, there cannot be a guilty mind and there cannot be a punishment. Similarly, between 7 to 12, whether similar provision is been made, there is a slight distinction between the earlier children of earlier age duration. Now, here between 7 to 12, the presumption is applicable only if the child, depending upon the maturity level of the child. So, therefore, when it comes to 7 to 12, the presumption or the exemption is still applicable but at the discretion of the court. If the court feels the child is still is not matured enough or still it is immature, then the exemption could be extended, that is the exemption of a dolly in capax could be extended to the other party. So, this is how IPC has given certain level of protection to the child.